Well, you've heard the ethics and you've heard the physiology, and now I've got to talk about what may seem like a very dry aspect, which is the law. But the reality is that in order to try to assure that you receive the treatment that is appropriately patient-specific and that is in accord with Catholic ethical teaching, you have to know about the legal framework that governs how those decisions are conveyed and made and enforced. So we're going to talk about four basic areas. One area, many people have heard, just about everybody has heard about the living will and what we generically call advanced directives. I'll be talking about that in a moment. But there's a much more recent development, especially here in Maryland, although it's around the country, that has a very direct impact on establishing what treatment someone is going to be receiving, and that's what's known as MOLST, for Medical Orders for Life-Sustaining Treatment. And what I'm going to ask, I hope you all picked up as you came in a copy of this handout that says Maryland Law on Life-Sustaining Medical Treatment. You might want to pull that out, and we'll refer to it as we're walking through this. Secondly, we will talk about advanced directives. Now, what is an advanced directive? An advanced directive basically is you can give directions as a patient related to the medical treatment that you're going to get if you're currently capable of making those decisions, if you're what's known as legally competent. But as we realize, of course, it is possible that you may lose that ability under certain circumstances with some progressive illnesses and with some sudden injuries. And the purpose of an advance directive is to give guidance, legally effective guidance, for how the treatment would be provided to you and who would make decisions on your behalf if you're no longer able to make those decisions yourself. And that's why it's called an advance directive. Then we're going to be talking about what happens if you don't have an advance directive. You know, if you are disposing of your property in a will and you don't have a will, well, then the state is going to write your will for you. Okay, it's something that's called intestate provisions, and it will say how all your property is going to be disposed of because you didn't say. Well, it's the same thing here. If you don't say yourself in your own advance directive how the decisions are to be made and who in particular is to be speaking for you, the state's going to step in and going to say, well, these are the people who will make the decisions supposedly on your behalf. And then I'm going to talk about something that's very important in Maryland, and that is when you're actually in danger of being denied treatment that you do want, and what are the legal remedies that exist. So let's start out by talking about the Maryland MOLST, Medical Orders for Life-Sustaining Treatment. And if you flip over the first cover page of this handout, you will see what is actually the Maryland MOLST form. Now, what is this document? Well, it's basically an order relating to medical treatment. And it's a very specific one, much more specific in Maryland than in most other states that have parallel versions. And this is a set of medical orders. In most states, it is optional, but in Maryland, it is mandatory. And basically, the Maryland law is that whenever you are being admitted to, other than a hospital, just about any sort of medical care facility, and even an assisted living facility, or home health care, a MOLST document has to be filled out by medical personnel to describe what treatment you will and will not get. And if you are in a hospital and you're being discharged from that hospital to any one of these other levels of care, it is again mandatory that a doctor or other healthcare professional in the hospital has to fill that out for the patient before the patient is transferred. And this document goes with the patient And although it can be subject to review and change, which is a very important point, it controls the treatment that that patient will receive or will not receive when transiting to another healthcare level of healthcare. Unlike in most other states, these are documents that don't have to be signed by the patient or somebody who speaks on the patient's behalf. It's signed by the medical professional. But the facility does have to offer the patient or the person who's legally empowered to make decisions for a patient who can't make those decisions for himself or herself the opportunity to participate in what's going to be on that form. And you will see that following the form itself in your handout, there is what's called a healthcare decision-making worksheet. And this is the opportunity for the patient. This is not required, but it is optional, it's recommended. And this is the opportunity for the patient or those speaking for the patient, before this MOLST form is filled out by the healthcare professional, to indicate for yourself what treatments you would want or would not want. There is a requirement. You know, you've heard the idea of a second opinion, okay? There is a requirement that whoever is filling out this document, this MOLST document, has to allow you to bring in another healthcare professional. And, you know, that is often very important, especially when you're in a situation when you are potentially, when someone is, let us say, moving to a nursing care facility or an assisted living facility or something of this sort, where you're not in an emergent situation. It's often, you know, very frequently, medicine gets very highly specialized. And we've got hospitalists taking care of you in the hospital instead of your family doctor, and you've got specialists dealing with this. And these have significant benefits because they're the ones who are trained in the particular care area that they're doing, but it also means that there's often a disconnect with the patient and with the family of the patient. And you may want to be able to bring in, let's say, the family doctor who has known you and has known the family to be involved in helping in this decision-making process. With an important exception, which we'll get to, there is a requirement that the MOLST form be consistent with the wishes of the patient or the person speaking for the patient, okay? And that's the known decisions of the patient that might be on this worksheet, let's say, or the directions of a healthcare agent. We'll be talking about what that is in a moment, or surrogate. We'll get to that in more detail, or any advanced directives that the patient may have. Now, there is an exception to this, and the exception is if the healthcare professional considers a treatment to be ethically inappropriate or medically ineffective, then they are not required to follow the decisions of the patient. As we'll see at the very end, there's a way that you can act to try to protect your right to receive treatment when they're not willing to do that. But the important point I want to emphasize here is it's important to recognize that not all healthcare professionals share or agree with Catholic ethical teaching. So, for example, one of the important points you heard Father make is that in Catholic teaching there's a very important distinction between making judgments about the benefits or burdensomeness of the treatment in comparison to the benefits or burdens of the life. And that is critically important. A treatment may be burdensome. A life is never burdensome, okay? Every human being's life has inherent dignity and value and worth because each of us is a child of God. And the Church teaches that you can't say that because somebody has Alzheimer's disease or because somebody has a disability, let's say, that that person's life is less worth living. Now let me make one other important point about the MOLST form. You heard Father say the judgments shouldn't be made about the procedure specific. It has to be about the patient specific, and fact specific. And you just heard about how in the course of an illness, there are different stages, and there are treatments that are appropriate for certain stages that may not be appropriate for other stages. Now, one of the dangers here is when you have a document, particularly a legal document, that is very specific about particular procedures and says, oh, I don't want this procedure is not to be given, or this procedure is to be given. And when that's legally binding, okay, particularly if you say no to something, there's a great danger there that the judgment there may not be appropriate to the person's particular situation at any particular time. And we'll talk a little bit more about this when we get to advanced directives and sort of the distinction between just spelling out all the details in the advanced directive versus naming somebody who can make decisions on your behalf in light of basic principles. But talking about the MOLST for a moment, the theory behind the MOLST and similar documents in other states is that it is supposed to be a document, unlike an advanced directive, which sort of is applicable indefinitely into the future, all right, unless it can be changed and revised, but the idea is it's setting the principles for the future, the whole course of the future. The MOLST, in theory, is supposed to apply to the patient's condition specifically at a given time, okay? Now, I would say, unfortunately, that's not quite as clear in the Maryland document as it is in some of the documents in other states, which talk very specifically that it has to be reviewed and subject to revision whenever there's a substantial change in the patient's condition, and then requirements for regular review at specific intervals. That's not in the contemporary MOLST form. But it does say that it is subject to updating, and it's subject to updating at the instance of the patient as well as at the instance of the healthcare professional. So the point that I would make, which I think should follow from what you've heard from both of the previous speakers, is you can't escape this MOLST. It's going to be filled out whether you cooperate in it or not. So you definitely want to cooperate with it. You definitely want to fill out that healthcare decision-making sheet. But think about it for the condition of the patient at this moment, okay? And then be prepared to be aggressively assertive, I mean pleasant and polite, but assertive in asking for a revision of it when the patient's condition changes. Okay, that's very important. Now let's talk about advanced directives. This is a separate legal document, and it essentially is prior instructions that come into effect when someone becomes incapable of making healthcare decisions. Now, you've heard about the living will, all right? And the living will document, which was sort of the original sort of these advanced directives, was very focused on it was primarily focused really on saying no. And it would have sort of general statements and would say, we don't give extraordinary treatment, don't give artificial means, don't give, and it would sort of list this laundry list of things and say, I don't want it. And it might have a trigger that says if I'm terminally ill, okay? But a very rigid document. Now, after that, there came into effect something that came to be called a power of attorney, a healthcare power of attorney. And in Maryland, what we now have is one advanced directive document that allows you both to give specific instructions and to appoint somebody who's called in Maryland a healthcare agent. And this healthcare agent is the one who then, if you are unable to speak for yourself, is to, on your behalf and consistent with the principles that may be spelled out in the document, make the specific judgments about the treatment that patient is going to have. And one of the difficulties with having an advanced directive that states what treatment one does and does not want without appointing a healthcare agent, we've already stressed, and that is to the extent it's very specific, it can't take into account changes and unforeseeable future circumstances. And there's another point, which is that because in a certain sense it has to be general, it is open to widely varying interpretation. The advantage of appointing a trusted healthcare agent allows that person to apply the principles that are set forth to the specific circumstances of the particular case. Now, you might say, well, then maybe what I should do is just have a document that just appoints an agent. But there are some downsides to that, too. First of all, even though it's a good idea not just to pick one person, but to say, and if this person isn't available, here's a second person, and maybe even a third person, right? Because you know, the person you pick may be in a common accident, let's say, all right? But even if you have that redundancy, we don't know for sure what's going to all happen to us, and it's possible that that person will not be available. And it's not, you know, that you won't even have any of the backup agents available. And in that case, if you haven't had any guidance at all right, then you don't have the degree of control that you would want to have over the treatment decisions and ensuring that they're done in an ethical manner. And the other factor, and this is an important one, is that the person who is appointed as your agent may come under tremendous pressure by putting language in the document that establishes those basic principles. That gives your agent something to point to and say, no, I'm not just out here trying to torture Grandma. This is what Grandma wanted. She wrote it out in the document. These are the principles she said she wanted that I'm applying here. What are the requirements for an advance directive in Maryland? Well, it can be done by any competent individual who's able to make decisions for himself or herself at the time. It can be written or it can be electronic. It has to be dated. It has to be signed by or at the direction of the patient. And it has to have 2 witnesses sign it. Now, there are some exclusions I won't go into about who can't be a witness. It is important to recognize, especially when you're writing those specific things that you want to say you're going to reject, to realize there is a difference between ethical principles and legal documents. Let me give you an example. One very important Catholic principle, recognized in Catholic ethics, is that everybody has a duty to provide a just wage, right? You know, the employer must provide the employee a just wage. Suppose that all of your contracts, your employment contracts said at the end of the month, employer will give employee a just wage. Do you think maybe at the end of the month there might possibly be a little bit of disagreement between the employee and the employer about what that wage should be? Okay? The employment contract and legal documents generally have to be much more specific and say it's, you know, so many dollars at this particular time. Well, in a similar way, if you simply have something like the benefits don't exceed the burdens or no extraordinary treatment, these may be general ethical principles, but in a legal document, they are open to a wide variety of interpretations and misinterpretations and misjudgments. So this is, again, why it's wise to give the representative the ability to apply that. You ought to understand that if you don't appoint a healthcare agent, there's a default process. And at the top of the line, it's a guardian if one has been legally appointed, then the patient's spouse or domestic partner, then an adult child of the patient, then a parent of the patient, then an adult brother or sister, and finally a friend or other relative of the patient. And if it's a friend, there's an elaborate process of certifying that the person knows the individual well enough. Now, one of the things that is, I won't say unique about Maryland law, but you may consider sort of a problem, is that it's very rigid in the sense that if there's somebody in a higher class, the people in the lower class have no say whatsoever, legally speaking. Okay? So if there's a spouse and the adult child has a different viewpoint, that different viewpoint doesn't matter at all. Okay? So again, this is a reason why it's advisable to try to designate on your own who the healthcare agent would be. There are 2 protective provisions that you need to know about in Maryland law. One is that says that if the healthcare provider is aware that the patient has expressed disagreement with the action, for example, cutting off treatment, then they are not supposed to be able to do that. And then there's a very important point that if a healthcare provider is going to deny treatment or food and fluids against the wishes of the healthcare agent who's been appointed or the surrogate, then the person has to be given an opportunity to transfer to somebody who's willing to provide that treatment. And a very important point, pending the transfer, comply with the instruction of a competent individual or healthcare agent for an individual who is incapable of making an informed decision, if a failure to comply with the instruction would likely result in the death of the individual. So they don't have to comply if it's truly physiologically futile, if it's truly useless. But if they're making a quality of life judgment that says, hey, I know this is going to cause hasten the patient's death, but I just don't think the life is worth living, then under Maryland law, you do have the right to have access to that treatment. So what I would end with saying here is, this is something you should not put off, okay? You don't want to be in the situation where other people are making the decisions that you would not make and that would not be compatible with your Catholic ethical teaching. So please be prepared to go over that worksheet for the MOLST for a particular condition when someone, you or a family member for whom you're responsible or someone else for whom you're responsible, is being on the verge of it being admitted to one of these healthcare facilities. And please, you and every member of your family should prayerfully but definitively put together an advance directive. Fill it out legally, name the people, share copies of it with the people you name as healthcare agents, share copies of it with your family, make sure that a copy is in your medical record with your family physician. Thank you very much.